Next year, 2023, will mark the centenary of the Geneva Protocol on Arbitration Clauses. It's an interesting centenary because even in 1923, the protocol happened almost unnoticed. If you look at the law journals of the day, the key things like Clunet had virtually no reference to the protocol being signed at all. And yet it remains the starting point for our journey through various international instruments like the New York Convention, like the European Convention of 1961, and ultimately the UNCITRAL model law in its two different versions. 1923 is when the story of international agreements and discussions about arbitration producing real results begins. And so I thought it was a good idea to do a short video looking at the protocol itself. It's a very short document, quite unintimidating, and yet it does occasionally cause muddle and confusion. And you can sort of see in its text why ultimately it needed to be replaced. Having said that, anyone who studied the horrors of Article 2.2 of the New York Convention will know the advantages of the protocol in this respect. Let's actually have a look at the document itself, study it properly, because you need to do so. Here it is. What it begins with is a statement that the contracting states recognize the validity of an agreement, whether relating to existing or future disputes. And that's hugely important. This gets rid of the distinction found in the original Code Napoleon and in French law until 1925. Watch that date because it's influenced by the Geneva Protocol, between the clause compromissoire, the future disputes clause, and a compromis, that's the agreement to submit an existing dispute to arbitration. So this gets rid of that distinction in Article 1, but only obviously in the cases covered by the protocol. And for that, it is necessary for the agreement to relate to commercial matters or any other matter capable of settlement by arbitration. But there is then a reservation that each contracting state can use to limit the obligations to contracts considered as commercial under its national law. We have that reservation in Article 1 of the New York Convention, and it causes some problems when some countries with strong state dominance of commerce will have a funny habit of declaring things to be commercial or other not commercial that most people would regard as being of the commercial variety, but never mind. Article 2 is often ignored because it's largely superseded by the New York Convention Article 5.1d and arguably the Geneva Convention of 1927. Nevertheless, it makes the bold statement that the arbitration procedure, including the constitution of the tribunal, shall be governed by the will of the parties and the law of the country in whose territory the arbitration takes place. Now that creates an immediate question mark as to what happens when the law of the country in whose territory the arbitration takes place and the will of the parties conflict. The case law on the New York Convention is fairly clear that unless there's an expression of the will of the parties to have a procedure which contradicts the law of the country in whose territory the arbitration takes place, we basically play it by the law of the seat. More and more, the parties' agreement is pretty much sovereign unless it breaches the principles of natural justice. But Article 2 doesn't answer the question as to what happens if the will of the parties and the law of the country in whose territory the arbitration takes place are in conflict. And one can read it, I suppose, as requiring the procedure to comply with both, which is not a bad interpretation, actually. It makes a good deal more sense than Article 5.1d of the New York Convention, which places the parties' agreement ahead of the law of the seat of arbitration. Otherwise, well, the contracting states agree to make it easy to run a procedure in accordance with their law on arbitration. Well, that's not particularly radical in itself. One thing we should note is the scope of the protocol. It covers disputes between parties subject respectively to the jurisdiction of different contracting states. That was got rid of by Article 1 of the New York Convention. It doesn't really matter where your parties are or what laws they're subject to. This provision in Article 1 does cause the odd problem when you try and work out what it means to be subject to the jurisdiction of a particular state. The New York Convention approach, of course, is to operate in terms of the place where the arbitration is due to take place, at least as regards the enforcement of arbitration awards. And as regards the enforcement of agreements, the subject of the protocol, of course, the New York Convention is famously silent, which has led the Swiss to interpret Article 2 in line with Article 1, namely that Article 2 only applies if the seat of arbitration is outside Switzerland, whereas the United Kingdom traditionally interprets the scope of application of Article 2 as being limited to international cases as defined by English law. Neither is particularly supported by the wording of the convention. And of course, English law has now got rid of in the 1990s, the distinction between domestic and international arbitration, rendering the whole point a bit academic. Moving onwards, we then find that Article 4 requires the tribunals of contracting parties, faced, remember, with parties both subject to the protocol, so both subject to jurisdictions that have ratified the protocol, that when they've got a dispute, they must refer the parties to, on the application of either of them, to the decision of the arbitrators. You don't do it without a request from one party, but that's basic common sense. It doesn't stop courts from having jurisdiction in the event of a problem with the arbitration, but it doesn't ask the question of which law, or answer the question for that matter, of which law governs the arbitration agreement or the inoperativeness of the arbitration clause. And then all of a sudden, the protocol comes to an end. So what does this really mean? Well, what it really means is that the national court, faced with proceedings brought in breach, arguably, of an agreement to arbitrate, where one party requests referral to arbitration, has to apply its own conflict of laws rules to decide what the law governing the arbitration agreement is and whether or not under its or that law the arbitration clause is capable of being enforced. I hesitated a moment because you can have the situation, obviously, where the dispute is not arbitrable for good public policy reasons in the court seized by one of the parties. And in that situation, under the court's perspective, the arbitration cannot proceed, and therefore there is no referral to arbitration, regardless of what the law applicable to either the arbitration agreement or the arbitration procedure happens to be. What is noticeable here is the absence of any formal validity rule. Now, in the 1920s, with the exception of Sweden, formal validity rules were pretty much uniform, although what they actually said varied a great deal from one country to another. And we will see in due course the way in which this develops. But the protocol leaves it up to the national court seized by one of the parties in breach of the arbitration agreement to apply its own view of private international law and its own views of public policy to determine whether or not the agreement or the arbitration cannot proceed or become inoperative. And it's that becomes the subject to a degree of Article 2.2 of the New York Convention, which lays down a minimum standard, so it was thought at the time, for formal validity, requiring national courts in any event to enforce an arbitration agreement contained in an exchange of letters or telegrams or in a document signed by the parties. The protocol is significant. It sets in motion the Geneva Convention of 1927, which covers enforcement, and it leads us eventually to Article 2 of the New York Convention, and I suppose ultimately to the two different versions of the 2006 versions of Article 6 of the Model Law. I hope you found that interesting. It's a convention that's worth taking seriously because it's the beginning of a lot of what we study. Thank you.